Hi everyone, I'm Jayvee Martinez. Today we're going to answer some question which will serve as our final oral exam. So let's start. First question, define evidence and its scope. Rule 128 Section 1, evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Rule 128 Section 2, scope, the rules of evidence shall be the same in all courts and in all trials and hearings except as otherwise provided by the law of these rules. Next question. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind of character tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Meanwhile, the cumulative evidence is the additional evidence of the same kind and character tending to prove some point. To prove the same point, this is purely the accumulation of similar evidence that is derived from common sources. Next question. What are the three kinds of evidence? So the three kinds of evidence are object as evidence under Rule 130 Section 1, documentary evidence under Rule 130 Section 2, and the testimony confined to personal knowledge or the testimonial evidence under Rule 130 Section 22. Next question. What is a prima facie evidence? Prima facie evidence is evidence which is unexplained or uncontradicted is sufficient to sustain a judgment in favor of the issue supports. Otherwise said, if the opposing party does not offer unexplained and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of the party who offers the prima facie evidence. Next question, what is dying declaration? Dying declaration, the declaration or statement of dying person in this case is hearsay because it was given the outside of court. Despite the fact that this statement is hearsay, this statement is admissible in evidence because of the belief that a person who is about to die will not lie. It is important to note, however, that for this exception to apply, the statement is offered as evidence of the cause and surrounding circumstances of the death of the declarant. Next, what about statements uttered as part of the registé? Part of the registé or things done refers to the circumstances, facts, and declaration that growth out of the main fact and serve to illustrate its character. It includes the exclamation and statement of those who perceive the crime, made immediately before, during, or after its commission. It also includes statement made immediately after the commission of the crime as long as they were spontaneous. Next question. What is the order of examination of individual witness? Briefly defined each. Rule 132A Section 4. These are the following. The direct examinations, cross-examination, and redirect examination, its purpose and to extend, and the recross examination. Rule 132 Section 5. Direct examination. Direct examination is the examination chief of a witness by the party presenting her on her facts. Next is the Rule 132 Section Rule 132A Section 6, cross-examination, its purpose. Upon the termination of the direct examination, the witness may be cross-examined by the adverse party on any relevant matter. Rule 132A Section 7, redirect examination, its purpose and extent. After the cross-examination and witness has been conducted or concluded, he or she may be re-examined by the party recalling him or her to explain or supplement his or her own answer given during the recross examination. Lastly, the Rule 132A Section 8, recross examination. Upon the conclusion of the redirect examination, the adverse may be examine the witness the matters stated or redirect examination, and also such as the matters may be allowed by the court in its discretion. Lastly, the Rule 132A Section 9, recalling witness. Next, briefly explain the Judicial Affidavit Rule. Judicial Affidavit Rule or the JAR took effect on January 1, 2013. A normal court proceeding will take around 3 to 5 even more years to be fully decided. By requiring the submission or written affidavits of witness through the JAR or the Judicial Affidavit Rule, the time for requiring submission of written affidavits of witness through the JAR, the time for concluding a court proceeding will be shortened. The JAR thus seeks to decongest the the ever-increasing caseload in the country brought by the high number of cases filed each. Next, an offer of compromise in criminal case as admission of guilt. So there are only two exceptions of compromise as an admissible. So first is the quasi-offenses or acts defined and penalized under Article 365 of the Revised Penal Code or the RPC, reckless imprudence and simple imprudence or negligence. Second is those allowed by law to be compromised. Their usual examples are found in the Revised Penal Code, particularly in Article 266D of the RPC or the Revised Penal Code. Next, in order for evidence to be admissible, it must be relevant and competent. When is evidence relevant and competent? Relevance under Rule 128, Section 4, evidence is relevant if it has a relation to the fact in issue as to induce belief in its existence or non-existence. In addition to relevance, admissible evidence must be competent. Under Rule 128, Section 3, evidence is competent if it's not excluded by the law or these rules. Next question, what is a leading question and when is it allowed? Under Rule 132A, Section 10, leading and misleading question, a question is suggested to the witness, the answer which the examining party desires a leading question. It is not allowed except first on cross-examination, on preliminary matters, when there is a difficulty in getting direct and intelligible answers from a witness who is ignorant or a child of tender years or a feeble mind and a deaf or mute. And next is D, of a unwilling or hostile witness. And lastly, of a witness who is an adverse party, of an officer, director, or managing agent of a public or private corporation, and a partnership association which is an adverse party. Next question, what is a misleading question? A misleading question is one which assumes as true a fact not yet testified to by the witness or contrary to that which he has previously stated. Next question, when is circumstantial evidence is sufficient for conviction? Rule 133, Section 4, circumstantial evidence, when sufficient circumstantial evidence is sufficient for conviction if there is more than one circumstance. Second, the fact from which the inference are derived from proven. Third, are the combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Next is distinguish burden of proof from burden of evidence. Rule 131, Section 1, burden of proof is the duty of party to present evidence on the facts in issue necessary to establish his or her claim of defense by the amount of evidence required by law. Burden of proof never shifts. Burden of evidence is the duty of the party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. Burden of evidence may shift from one party to the other in the course of the proceeding depending on the exigencies of the case. Next question, what is the standard of proof necessary in civil cases? Rule 133, Section 1, preponderance of evidence. How determined in civil cases, the party having the burden of proof must establish his or her case by the preponderance of evidence. Second is the proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Third is the substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it's supported by the substantial evidence or that the amount of the relevant evidence which is a reasonable mind might accept as adequate to justify a conclusion. Next, define what are public documents. The provision above enumerates the kinds of document considered as public but the court of evidentiary purposes. They are public by reason of publication or making them known to third person or the general public. Next, how you defined or prove in court private documents. Rule 132, Section 20, proof of private documents. Before any private document offered as an authentic is received in evidence, its due execution and authenticity must be proved by any of the following means. First, by anyone who saw the document executed or written. Second is by evidence of genuineness of the signature or handwriting of the marker. Third, or lastly, by the other evidence showing its due execution and authenticity. Next question. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the 4 exemptions? First is the original document is lost or destroyed or cannot be produced in court. Second is the original document is the custody and the adverse of party or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes and procedures. Third is the original document consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. And lastly, the original document is a public record in the custody of a public officer or its record in a public office. Next, who become a witness? All cases involve stories, and storytellers who share their knowledge of the events to the court are called witnesses. They can be third persons who observe what happened, or they can be the parties themselves who are directly involved in the dispute. Then last question, when is an extrajudicial confession sufficient to sustain a conviction? Section 3, extrajudicial confession not sufficient for ground conviction. An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. Then lastly, thank you so much, and I hope that you learned something from this video.